So thank you, Noma, for that wonderful introduction. And thank you so much, Natural Justice, for giving me this opportunity to share and to just talk about a topic that is, it's really close to my heart. And it's a topic that I've done quite a lot of research on. So I am really, really excited to be sharing on this topic. So just a quick outline for today's presentation. So I will give just a brief overview of carbon markets and carbon credits, so basically what they are and how they function. Then we'll talk about Africa's entry into the carbon market space. Then we'll speak about the rights implications of carbon markets in Africa. And then we'll have a chat about the existing regulatory gaps in this regard. So starting off strong with what carbon credits are. So carbon credits, So carbon markets are systems in which carbon credits are created, traded, created, certified, traded, and used. So each credit represents 1 ton of CO2 or equivalent greenhouse gas emissions that is reduced or removed from the atmosphere. So carbon markets are like systems in which carbon credits are created, certified, traded, and used to offset greenhouse gas emissions. So they provide financial incentives to entities to reduce or remove greenhouse gas emissions from the atmosphere. And so in simpler terms, or like I would like to say in English, for better understanding and for better comprehension, carbon credits it's basically a certificate or a permit that proves that an entity has removed or prevented 1 ton of CO2 from entering the atmosphere. So this permit is then sold to entities that wish to cancel out their greenhouse gas emissions. And the credit seller would then earn money or benefits from that sale to create more carbon credits. So there are basically 3 types of carbon credits. Carbon credits that reduce emissions, carbon credits that remove emissions, and then there are those that avoid emissions. And the best way to explain how carbon credits work is to give a simpler example, a more elementary example, or like what I like to call a hypothetical example. So based on the picture that I have on the slide, we have an airline company that, for instance, emits a lot of greenhouse gas emissions. But that airline company is trying to be more environmentally responsible. So they're really wanting to take their carbon footprints more seriously. However, since it can't reduce all its emissions immediately, it decides to buy carbon credits from a credit seller. So that credit seller, in this regard, would, for instance, be an NGO in an African state that has, for instance, planted 1,000 trees or 10,000 trees. And that project is said to prevent, for instance, 10,000 tons of CO2 from entering the atmosphere. So after an international certifier checks that this project does give 10,000 carbon credits, the airline company would then buy half of those credits, so maybe 5,000 of those credits, and then from the credit seller to cancel out their own CO2. So that is what is called carbon offsetting, where a credit buyer, in this instance the airline, buys credit from a credit seller, in this instance the NGO in the African states, and then uses those carbon credits to compensate their own emissions. So the NGO would then earn money from the sale and use it to plant more trees, to support local communities, to create more jobs and all of that. But of course, I can already tell that some of the environmentalists in this room have question marks. Of course, this is just an example of how carbon credit works. But in reality, it is, it's a bit more nuanced. It's a bit more complicated than this. And yes, we are going to get to some of these issues as we go along. Also, there are two types of carbon markets. We've got compliance carbon markets. So what they do is they are regulated by a mandatory legal framework. So states set legally binding emission caps, and then entities that exceed these caps must purchase credits to cover their excess emissions. So another example in this instance is, let's say a company is only allowed to release 500 tons of CO2 per year. But in actual fact, they release 600 tons of CO2 per year. That company has no choice by law that it must buy 100 credits to cover that extra pollution that is being emitted into the atmosphere. And then voluntary carbon credits, these operate outside a mandatory legal framework and allows companies, organizations, or even individuals like myself and you to purchase credits voluntarily to offset their emissions or your emissions as part of sustainability or just, net zero commitments. So they are often project-based that include forestry, renewable energy, and community-based initiatives. And most importantly, on a regional scale, research shows that in Africa, there are predominantly voluntary carbon markets. So before we go into Africa's entry into the carbon market space, we're going to just have a quick overview of the historical foundations of carbon markets. So, as scientists highlighted the severe impacts of excessive greenhouse gas emissions to the climate systems, what states or countries then did is they came together to develop solutions through the form of treaties to protect this climate system. And the main solution that came about was the reduction of greenhouse gas emissions in order to protect the climate system in efforts to basically avoid the severe impacts that a non-protected climate system would have. And then carbon markets were then established as a mechanism to support emission reductions. And it was implemented on a national level and on an international level, but now it's being implemented on national and regional levels. And the first treaty that states adopted through their collaboration was the 1992 UNFCCC. And the objective of this treaty was to stabilize greenhouse gas concentrations. And it's basically the foundational treaty that established the international framework to address climate change. In other words, to set provisions for the reduction of greenhouse gas emissions. Then in 1997 came the Kyoto Protocol, which then operationalized the UNFCCC, and it basically introduced the carbon credit or the market-based system on an international level. And it also created flexible mechanisms for these carbon credits or carbon market systems. And now we have the 2015 Paris Agreement with the objective of limiting global warming to well below 2 degrees Celsius pre-industrial levels, with efforts to limit it to 1.5 degrees Celsius. And Article 6, Provision 6 of the Paris Agreement basically speaks of has provisions regarding carbon market mechanisms on an international scale. And so when we then look at Africa's entry into the carbon market space, it's important to note that while Africa has, in actual fact, always been part of the carbon market space, but in recent years, we've seen a rapid increase in African states or African countries wanting to just enter into this market in a rapid scale. And so why is Africa getting more and more involved in these carbon market spaces? So according to the research that we had conducted, Africa receives less than 10% of the 1 trillion mobilized globally through carbon funds and initiatives. So this severe underfunding climate change underfunding has driven African states to explore carbon markets as a supplementary source of climate finance. So that's one of the reasons why African states are saying that they want to get more and more involved into the carbon market space. So as a form of supplementary source of climate finance. And also, Africa holds vast carbon sinks. So we've got forests, we've got peatlands, we've got grasslands, which can create carbon credits. But in the past, Africa has not been included in a lot of these climate change programs. So, for example, under the Kyoto Protocol, which, like I said, introduced this carbon market system or carbon market mechanisms, Africa only got less than 3% of the projects, while a country like China got about 60% of projects. So in essence, basically, Africa wants to be part of the space too. So we want to be part of this climate or this carbon market space. And so it seems like, Africa's entry into the carbon market space is often framed as part of a broader, effort to attract investment into, the continent's vast carbon potentials for climate mitigation, adaptation, and just sustainable development as a whole. So carbon markets are, frequently promoted as a tool that can reduce, emissions, support sustainable development, and, to mobilize climate finance in Africa. However, and I make that very, very clear, that there are challenges in this regard, because in practice, and this is based on the research that we've conducted, the reality on the ground often differs. So it has been, seen that carbon markets are operating within exploitative frameworks that risk violating human rights, particularly land rights. So they're also said to undermine environmental justice and, importantly, replicating extractive economic models. And all of this is under the guise of, climate mitigation, adaptation, and sustainable development. And so some of the right implications of carbon markets in Africa, first and foremost, it is a huge threat to indigenous land rights. And so because these projects in Africa are often implemented in areas with unclear or customary land tenure systems, and then this leads to, land disposition and tenure insecurities for indigenous and local communities. And so I give the example of the the Mayendombe REDD Plus project in the DRC, where local communities were excluded from decision-making processes and suffered restricted access to their ancestral lands without free, prior, and informed consent. So revenue sharing was inadequate. So it was said to be inadequate and inconsistent, while communities bore the burden of conservation limits on traditional agriculture, hunting, and gathering. So these projects really commodify land and forest stewardship practices that indigenous peoples have really maintained for generations. And it's now framed as carbon services to be sold to global markets. So this shift transforms communal land into capital assets for external actors, often without secure legal protections for these local communities and indigenous communities. So some other rights implications of carbon markets in Africa is, like I'd mentioned before, the extractive economic models. So despite being presented as a carbon solution, carbon markets in Africa really, in a great way recycle the same logic of extractivism that, have historically impoverished Africa in the past, but and is still impoverishing Africa. But now it seems as though it's under the guise of, green growth, net zero, sustainable development, job creation, opportunities, and all of that. And importantly, some of the key features of this extractive logic that we've researched or that we found is that forests and soil and air is no longer seen as ecosystems, but as carbon stocks for monetary value. And thus, really transforming Africa's landscapes into tools for corporate offsetting. So our ecosystems are no more seen as ecosystems. They're now seen as something that is of a monetary value. And then you also have high emitting corporations that will continue polluting while purchasing credits, cheap credits in African states. For instance, in the Mayendombe case, most profit benefited foreign projects, intermediaries, and international certifiers, while the African communities themselves were impoverished. And so because of all of that, there clearly is regulatory gaps in Africa with regards to carbon markets and carbon credits. Where the regulation does exist, there are gaps, and and overall there just is a limited amount of regulation. So it's really, the key challenge that has been identified is the weak, or I guess the non-existent regulatory framework governing carbon markets in Africa. So really, despite an onwards appearance of progress, regulatory landscapes for carbon markets in Africa remain fragmented, centralized, and deeply inadequate from a human rights perspective. So the absence of binding, human rights protections, inequitable benefit distribution, and the failure to protect land rights means that carbon credits currently serve global emitters, private developers, far more than it actually serves, the African continent, or the people, indigenous peoples or local communities whose lands, forests, and futures are, futures are being commodified. And so something that we had quoted in our report was that until carbon market regulations meaningfully protect rights, rights, land rights, participation, and justice, the markets will continue to reproduce extraction in the green, in a green disguise. And so some of the regulatory gaps that we've identified is, firstly, there's a sense of central government control. So regulatory and administrative powers are heavily centralized within government ministries and national councils. So local governments and local communities and local communities often lack legal standing or participation rights in the design of these carbon market projects. Another regulatory gap is limited protections for communities. So customary indigenous land rights are often unrecognized or insufficiently protected, so allowing for carbon developers to bypass community ownership. Another regulatory gap is weak consultation mechanisms. So consultations are often informal, and it's just like a once-off meeting without legal force. There's also a lack of procedural rights to object or to appeal or to negotiate terms. So local communities can't really negotiate terms. So communities are rarely provided with accessible information or legal representation during design, the design of the projects. And then there are loopholes within the existing frameworks that exist in Africa. So, for instance, we noticed that there are vague definitions on who owns the carbon credits, especially for community land. There's also ambiguous roles of, the project developers versus, the roles of the state, versus also the roles of community, of the communities or community leaders. So there's no clear mechanism for tracking revenue flows or ensuring that the communities actually benefit from these carbon market projects. And enforcement is also a really big gap that we noticed in the existing regulatory frameworks. So there are no sanctions for, or no clear sanctions for violations of consultation obligations or even benefit sharing commitments. And then certification and verification bodies, for example, Vera, they operate with limited accountabilities to African regulatory authorities. So the regulations that do exist really, have some, loopholes, enforcement gaps. We notice that there are weak consultation mechanisms, limited protections, especially human rights protections for local communities, especially with regards to their land rights, and also just unclear challenges with regards to the central government control. So who do these carbon credits really belong to is some of the questions that we've had, and those that we couldn't answer because the regulatory frameworks were quite limited. And so one of the things that we really called for in the research that we did was a just regulatory framework. And so what a just regulatory framework in Africa, in the carbon market systems in Africa, what that means is really legal recognition and protections of customary and indigenous lands, full, effective, and informed participation of local communities, transparent and equitable benefit sharing mechanisms, independent and accessible grievance and redress structures. Those are some of the the elements the important elements that need to be included in these regulatory frameworks for carbon markets in Africa. And this would really lead to a more just regulatory framework, especially for those that would be most affected by carbon market spaces. So without this paradigm shift, so without this, this just regulatory framework, carbon markets in Africa really risk becoming financialized enclosures of African lands under the guise of, climate mitigation, climate adaptation, and sustainable development. This is really a call for a paradigm shift, a call to really change or to adopt a regulatory framework that is just. And just, like I said, is just for the local communities and those that will be most affected by carbon market spaces in Africa. And so this does bring me to the end of my presentation. Thank you so much for your time and participation. I do look forward to further discussions on this topic and for an insightful Q&A session later on. Thank you.
Thank you so much, Yasmine. That was quite an insightful and foundational presentation, I think, on what exactly carbon markets and credits are, and also what some of the issues that we're likely to encounter if we welcome some of these markets to our shores. You touched on justice issues, you touched on the issues of equity, of transparency, issues of sovereignty even. From that perspective, these I think are all incredibly important concerns that we need to start talking about and that we need to start learning about. Just from the poll, 47% of you highlighted that you are just getting started in terms of learning about carbon markets and credits, and you're here to learn. So I think that presentation really sets a good foundation to be able for us to have more dialogues in the future. I would like to point out to our attendees that SEJA, as well as ALCA, have actually been working on a research report, a sort of guidebook that is going to be able to assist a lawyer who's interested in learning about carbon markets in their specific jurisdiction, what the regulatory regime is like in their jurisdiction. Any lawyer who's willing to engage with that information should please access our guidebook. It's going to be put up on our website very soon after this webinar in the next week or so. So please look out for it. And that's going to be the guidebook that we're hoping that you will use when you want to start challenging, if you do want to challenge some of these projects that are in your back door. So we're going to shift our focus a little bit slightly now, and we're going to go into some of the more practical elements of dealing with regulation that either does exist. So for a lot of these African countries, Yasmine had mentioned that there's weak regulatory systems, but for a lot of African countries, they're also new regulatory legal systems. In other words, they're pushed out by different governments very quickly without any consultation with civil society or with lawyers in those specific jurisdictions. But for those jurisdictions where these regulatory frameworks exist, what has been the atmosphere there? What has been the reception there? And what are some of the issues that we need to look out for? And Fiona is going to be able to take us through that discussion. So let me welcome Fiona now. Fiona is a human rights and environmental lawyer who's duly qualified she's got dual qualifications rather in both Zimbabwean as well as English law. She works as a senior legal counsel and consultant coordinating the American Bar Association Center for Human Rights and Justice Defenders Program in Sub-Saharan Africa. The program supports civil society organizations and human rights defenders, including environmental human rights defenders who are at risk. It does this through trial monitoring, technical legal support and advocacy, pushing back against restrictive legislation and practices to protect civic space in that region. She also holds a master's in international human rights law from the University of Essex and practices at Winterton's Legal Practitioners in Harare, providing legal support to individuals and communities challenging unlawful activities and developments causing environmental and social harm. Fiona previously worked for many years in local human rights law organizations in Zimbabwe as a litigating lawyer and program manager, specializing in compensation claims for victims of security sector brutality, environmental cases, and research and advocacy on all issues of human rights law, particularly judicial harassment of human rights defenders and restrictive NGO legislation. Fiona sits on various nonprofit committees and boards supporting environmental and human rights causes. Please welcome to the floor, Fiona Illiff. Fiona, go ahead, please.
Thank you so much, Norma. Claire, would you mind sharing my slides? And thank you, Yasmine, for that incredible presentation. That was a really good introduction to look at our domestic framework in Zimbabwe, which has only just been launched 2 weeks ago. So we really need that kind of expertise to look into the regulations and push for reforms where possible. I'm just hoping that we can share the slides full screen. Wonderful. Okay, thank you. Okay, so I'm going to be speaking today about the carbon trading framework in Zimbabwe, which has recently changed. And we've moved from a voluntary market to a compliance market. Just to give you a brief background on Zimbabwe's context, Zimbabwe is an incredibly beautiful country. I know I'm biased, but it's very rich in natural resources and biodiversity. We have a lot of somewhat protected areas, so a lot of huge national parks like Hwange National Park. A lot of people will have heard of Victoria Falls. We have forest reserves, wildlife reserves, and we have extensive headwater wetlands and river networks that also feed into neighboring countries. We also have a lot of mineral resources, and actually that's in some ways causing the population more challenges than benefit in recent years, with a lot of foreign companies coming in and mining in an irresponsible way. We also have quite a lot of political and economic challenges. We have a colonial legacy. A lot of although we have these national parks, it is a sort of colonial conservation model. A lot of local communities were evicted for those parks. So a lot of the local communities live on the outskirts of the park. There's a lot of conflict with wildlife. Because of we've had the same political party in power since independence in 1980. So that party has become very authoritarian. There's a lot of corruption and there's limited transparency in decision making. Although we have the same party, in 2017 there was a change in administration and president, and the new president has stated that Zimbabwe is open for business, so encouraging all types of business to Zimbabwe, but some of that business is not necessarily responsible business. We also, in recent years, have a lot of, well, actually since the 2000s, we have a lot of challenges with judicial independence, and human rights defenders are also at risk from the security sector and communities challenging extractive industries and practices that they don't agree with. We also have a lot of energy challenges. And so the country is still very focused on coal power, even in like Hwange National Park. And that's getting closer and closer to the cities and communities. So there's a lot of pollution challenges. So that is just the context within which this carbon credit model that, as Yasmine highlighted, is a very sort of corporate model is coming in Zimbabwe. So what domestic frameworks do we have? We have ratified a lot of the international environmental treaties, such as the United Nations Framework Convention on Climate Change, the Kyoto Protocol, Paris Agreement, Convention on Biological Diversity. This year, we're going to be hosting the Convention of Contracting Parties for the Ramsar Convention, that's on wetlands of international importance. And we have some good domestic laws. We have quite a good constitution since 2013, which is very similar to the South African one. So we have protection of the right to a healthy environment, water, food, access to information, administrative justice. And we have acts like the Environmental Management Act, Parks and Wildlife Act, Forest Act, Water Act that protect particular resources and areas. And then in terms of climate change management, we do have a national biodiversity strategy and action plan, national climate change response strategy. But I would say all of this is somewhat new and not necessarily properly implemented yet. But there's been a lot of movement in the last few years. We have a climate change bill before Parliament that will hopefully pass, and a draft carbon market framework. And then just 2 weeks ago, these new carbon credit trading regulations came in. We also had some previous regulations in 2023, but the new regulations have actually improved on those regulations. So there are positives to take away from these developments. Unfortunately, in Zimbabwe, we still have these challenges that were mentioned in Yasmine's presentation of land rights, limited land rights for communities. So we have this colonial legacy of communal lands, which are controlled by the chiefs. So the government has, over the last 20 years, used those acts to control rural communities somewhat. So it's difficult to really access communities and really get informed consent, except through the chiefs. So that will be a challenge. Also, the Communal Lands Act doesn't provide much protection to land. The use can be easily changed. So we've had challenges with development projects where communal land has been changed for another use. Similarly, with even the Parks and Wildlife Act, we found that mining claims and grants can still be granted in protected areas like national parks. And there's a very limited transparency under that act. So there are a lot of challenges, but there are also a lot of legal provisions that could be used in a positive manner if there was goodwill. Specifically looking at carbon trading, Zimbabwe up until now has had an unregulated voluntary market. And there was a very famous project called the Kariba Red Project. The red stands for reducing emissions from deforestation and forest degradation in developing countries. So these are often projects that are used for carbon offsetting. So this was a huge project covering 785,000 hectares of forest, and generated, since 2011, apparently generated more than 36 million carbon credits with more than 100 million euros revenue. It was a partnership between a Zimbabwean organization, Carbon Green Investments, and South Pole, which was a Swiss carbon offsetting company trading in carbon credits. And it was also verified by an independent crediting standard, that's Vera. So for a long time, between 2011 and 2023, they were making a huge amount of money on the voluntary market. And then there was an investigation through Follow the Money and the New Yorker in New York Times Magazine in the US did an investigation. And what they found was that what was being sold to a lot of international companies claiming to have been net zero, like Gucci, for example, Volkswagen, were buying these expensive credits. What was being sold was very different to what was happening on the ground. So there was a lot of exaggeration with regard to how much forest degradation there had been and was being restored, and the emissions reductions were just not verifiable. So there was an overissuance of credits, and also a failure to deliver the benefits that they said they were delivering to the local communities. So this led to an international scandal beyond Zimbabwe, with a lot of people questioning whether the carbon credits were actually working for communities, for the environment, or whether it was just some rich boys making lots of money. It did lead to the project, to South Pole drop the project, and the project was suspended from Vera. And then the Zimbabwean government responded by suspending all carbon trading projects in 2023. They later did gazette the carbon trading regulations of 2023, which were better than nothing. They introduced registration, regulation, revenue sharing, but there was very limited stakeholder consultation, inadequate community representation, unclear revenue sharing models, and lack of enforcement mechanisms. So since that time, they've continued to work with international partners on developing a better framework and new regulations, which we've seen this year. But even at that time, when they passed those 2023 regulations, there was an MOU that was signed with a UAE company called Blue Carbon, which has also been trading in countries like Tanzania and Liberia. And this MOU has received a lot of negative press. People are very concerned. I think also because of UAE companies' activities in Tanzania, like in wildlife areas where the Maasai have been evicted, and a lot of those wildlife areas have been restricted to hunting conservancies. So generally, there's a concern about how this MOU will be implemented. It's also supposed to cover such a huge area of land, 5.1 million hectares, that is supposedly going to be used for reforestation, forest protection, ecosystem restoration, agroforestry, and agricultural management. And there's a bit of concern there with what sort of agriculture will they be doing? Will that agriculture be benefiting Zimbabweans, or how will this be done? And again, it's a huge amount of money. There was 1.5 billion to go to the Zimbabwean government, sorry, 1.5 billion investment for the project. And apparently it's predicted that there'll be approximately 18 million annual credits. And as I mentioned, the concerns are over the land use and rights. This much land, what is going to happen? Is it land that's already somewhat protected as national parks, for example? If so, what happens to those parks in terms of access and protection of the biodiversity that's already there, and the animals that are there, the communities that are dependent on that land? There's been very little transparency and accountability. Will these credits have environmental integrity, and will Zimbabweans really benefit from this project? So we're watching this space. I know in Tanzania they are as well with the blue carbon deals. And I have been involved in doing a freedom of information request around that deal, and we've been invited to go to the ministry and look at the documents. So that is a positive. I think with the new regulations, the ministry is trying to show that they are complying with international standards and allowing access to information. So we'll see how that holds up. So yes, 2 weeks ago, the ministry launched the new carbon trading general regulations of 2025. It has been sold as a really big deal. It was drafted by a Swiss expert based in Dubai, with some technical experts also from Dubai, who have really sold it as a lot of world firsts. It's the first Article 6 ready domestic compliance market in Africa. Of course, whether it's actually Article 6 compliant, that's Article 6 of the Paris Agreement. Whether it's actually compliant with the Paris Agreement remains to be seen in terms of the implementation. But in terms of the language, a lot of the language of Article 6 is in the regulations, shifting from an unregulated market to this Article 6 alignment. And it's this digital platform is the first national blockchain digital registry. So after the Kariba Red project, they are trying to address the concerns around verification of credits, double counting, over issuing of credits. So every time you transfer a credit on this registry, there'll be corresponding adjustments to prevent double counting. And that's with other registries. It's supposed to link with other registries. So if you retire, as soon as you make a sale, that'll be retired on the Zimbabwean system. And they're also trying to limit challenges with reversals. For example, if your project, you predict you're going to make so many emission reductions, but then actually something happens and there are less reductions than planned. There's a buffer account which allows for some reversals, protects against those reversals. There's also a national transaction account, so that the government benefits from the credits, and also when you make a transfer, the credits also count towards the nationally determined contributions under the Paris Agreement, so that the Zimbabwean government is still complying with its own obligations to mitigate emissions. And this system shouldn't be detrimental to those obligations. Yeah, so it's supposed to be fully integrated with other markets and trading. So looking more closely at the provisions, and I think it's beyond the scope of this presentation for me to go into full detail in terms of how you would go through the application process. It's very, very detailed, and very, very expensive, I would say. But just to highlight some of the key features, it establishes the Zimbabwe Carbon Markets Authority, which they're calling ZICMA, which is the designated national authority regulating the carbon market. And that authority falls within the Climate Change Management Department of the Ministry of Environment, Wildlife and Climate. And there is this Zimbabwe Carbon Registry, which I mentioned has this digital platform. So in theory, you should be able to see all transactions. It should be more accountable. You register as a project developer on the system. You then apply, you submit your reports. Every time there's a transfer of a carbon credit or mitigation outcome, it automatically shows on the system and makes these corresponding adjustments. And you also do fee payments on the system. And then, as I mentioned, there are these corresponding adjustments to the buffer account, the national transaction account, and to the nationally determined contributions. It makes it a compliance market, So you are required to register with the authority. You can't now just trade on the voluntary market. So even existing projects, you have to apply for registration and comply with these regulations. And if you don't comply with the regulations, your project can be suspended or cancelled. If you're not registered, it's actually a criminal offence. And as I mentioned, it tries to use the language of Article 6 of the Paris Agreement in terms of these transferable mitigation outcomes, cooperative approaches between countries towards mitigation of emissions, but you have to be first authorized by the authority before doing any of these mitigation outcomes, cooperative approaches, or participating in Article 6.4 of the Paris Agreement. So even if you're trading under the Article 6.4 mechanism, you still need prior authorization from the authority. And that's to try to prevent double counting, so trading on two registries. And again, because of the Kariba Red project, these regulations are very concerned with verification, having verifiable emissions reductions. So they're very extensive provisions requiring experts and auditors. They have to be licensed as designated operational entities who will verify that your project is actually making the emissions reductions that you say it is. And then there are a lot of requirements for monitoring and reporting. I would say where the challenge comes in is, as mentioned by Yasmine, although there is all this auditing and verification, which is much better in terms of environmental integrity, in terms of emissions reductions, when it comes to community rights, there are still a lot of challenges. There are a lot of safeguarding provisions and provisions on free, prior, informed consent. So it's a lot better. But for example, the regulations establish a national grievance mechanism, which they say is independent. But in fact, what you're actually doing is writing to the minister or someone designated by the minister with an affidavit. And then the minister refers it to a committee. And it's not clear how that committee is chosen or allocated. And then that committee can then make recommendations back to the minister. If they make recommendations that the project developers should be sanctioned, the authority can issue those sanctions. So it's not that it's not helpful to have the mechanism, it's just that it really needs to be improved to be made more accountable and effective. And it does provide for an appeals procedure. It's to the minister. So you see it's all very controlled within the Ministry of Environment. Positively, you appeal to the minister and then the project is suspended pending the minister's decision. But then if you disagree with the minister's decision, you then appeal to the administrative court. And it specifically says that the project will not be suspended while it goes on to the administrative court. So if there is a lot of harm being caused in the meantime, that could cause a challenge, and whether you would then have jurisdiction in another court, like the High Court, to get an interdict is unclear. As I mentioned, these regulations introduce a lot of fees and levies. It's a very, very expensive market, I would say. So I do have friends in the environmental and conservation space that are very excited about these regulations and want to use them genuinely to protect the environment, who are unsure whether, as a small CSO doing planting trees, whether they can genuinely participate because the fees are so prohibitive. So there's a carbon levy, which is $1 per credit. There are very, very high fees. For example, I just put one example there for project registration. It's 10 to 20,000 US dollars just to register. That's whether or not it's approved. You pay extension fees. You have to pay to register your account on the digital system. Every time you submit some of the documents required for approval and reporting, every time credit is recognized, issued, transferred, retired, there's a fee. And then separately for independent crediting standards to register, they also have to pay a fee, and the auditors have to pay very, very high fees to be licensed on the system. And then I've already mentioned that every time you're issued a credit, you also 1% of that goes to the nationally determined contributions, 2% goes to the national buffer account, and then 30% of your emissions reductions, so that's your credit or the overall value of your proceeds, depending on whether it's a mitigation output or specifically carbon credit, will be credited to the national transaction account. And then this is positive. You are required to put 20% of your total investment towards local sustainable development. So that's the benefit sharing provision, that you need to put at least 20% of your total investment into the local community. And I'll come to that in more detail. And then tax is a big question. We don't yet know how much you will be taxed. So it's expensive. They have made an effort to introduce more rights and safeguards within these regulations. There are property rights protections for the carbon credits themselves. It states that the regulations ensure that all carbon credits and mitigation outcomes are afforded full property rights protections. But as mentioned by Yasmine, it's not quite clear what that means. What do carbon rights mean? What rights do these foreign actors coming in have over the land and resources that they may be protecting? But do those rights then also confer to the local community partners? And how this actually plays out in practice could be difficult. There are certain areas and activities that the minister can declare as ineligible for carbon credits, for reasons of environmental integrity and national interest. That could be a positive thing. And I've mentioned that the carbon projects can't negatively impact the country's obligations in terms of nationally determined contributions. They have to already continue with their emissions reductions under the Paris Agreement and Kyoto Protocol. I mentioned this local investment. So 20% of your investment is required to promote sustainable development locally. And that's towards things that are mentioned in the Sustainable Development Goals, the UN's Sustainable Development Goals, like gender equality, food security, water, education, local infrastructure, local employment, healthcare and sanitation, clean energy. And I just wanted to get a bit more detail. 50% of the sum is required to go to sustainable energy projects and water projects. So that's quite specific. And when you're making your application, you have to show how you have to have a clear plan developed with the community to show how you're going to do all of these things. I mentioned that there is a national grievance mechanism, which is somewhat problematic because it's very controlled by the ministry, but it is there at least. And then you're also supposed to, project developers are supposed to have project level grievance and redress mechanisms. And that's part of the free, prior and informed consent requirements that this mechanism is supposed to be developed with the community ahead of it being approved. So the community is supposed to agree how they can raise a complaint and how it will be dealt with. I mentioned there are rights of appeal under the regulations, and then there are these quite extensive safeguarding, environmental, and sustainable development standards. So in terms of the sustainable development requirements, carbon projects must make meaningful, tangible, measurable contributions to sustainable development. And the project proponents must evidence anticipated sustainable development benefits in their application, prepare a detailed investment and monitoring plan to show how these benefits will be realized and measured, and they have to have a clear exit strategy. So if suddenly the project ends, they have to show that these benefits will still continue to benefit the community in the future. And they have to continue to provide sustainable development reports. In terms of social safeguarding, mitigation activities that negatively impact communities, their livelihood, and their ability to exercise rights shall not be authorized by the authority. Proponents are supposed to negotiate with communities in good faith and ensure full representation of their diverse interests. They have to consider all sources of potential harm and take tangible actions to reduce the risks. And they have to, develop these project-level grievance mechanisms, which are supposed to handle complaints in a timely, transparent, and culturally appropriate manner, and allow stakeholders to submit grievances anonymously and without the payment of any fees. Then there are guidelines for stakeholder and public participation, as well as free, prior, informed consent. Proponents have to involve the public and affected stakeholders in all stages of the project development and implementation process. They have to submit a detailed stakeholder and public consultation plan, and this is all prescribed in the schedule of the regulations. They have to identify affected stakeholders, include them in the project inception, design, and implementation phases, obtain free, prior, and informed consent, submit long-term public consultation plans showing how stakeholder views, expectations, and interests are genuinely integrated into the long-term project management. And those public consultations must be held in situ, so at the site, area, ward, that the projects will be implemented, and conducted in a culturally appropriate and gender-sensitive manner, informing all parties of their rights and ability to access the national grievance and redress mechanism. And in terms of free, prior, and informed consent, local communities have the right to grant or withhold consent for activities that will affect them and their resources. This is clearly stated that the government of Zimbabwe recognizes this. So proponents have to obtain consent from all communities whose lands or resources may be impacted. And it states regardless of ethnic or tribal identity. And it must be documented in a mutually agreeable and appropriate written form, showing the extent and nature of the consent, the authorities that have granted consent. So if, for example, a corrupt chief granted the consent and the communities dispute it, then it has to be documented who granted that consent. And it has to confirm that communities were advised of their right to submit grievances, and then specify the project level grievance and redress mechanism that's been agreed. And that free, prior, informed consent has to be shown prior to the project proposal being submitted, so preliminarily, with the project idea note, and then full consent when you submit the project design document. I won't go too much into the environmental integrity requirements. As I mentioned, there is a big focus in these regulations about credits representing real verifiable emissions reductions and or removals through analytical science-based model in accordance with recognized certification standards. So I think those requirements and the regulations are quite thorough on that point, seeking to reduce overcounting and setting conservative baselines below the business as usual projections to account for any leakage or reversals. But it does, in terms of the environmental safeguarding requirements, it does state that there will be no approval of activities likely to cause significant harm to natural environments, resources, and biodiversity. So there are positives there. Coming to some of the concerns, I think a lot of the concerns raised by Yasmine are still there in spite of these regulations and new frameworks. But perhaps we can monitor them effectively and use some of the provisions that are there to try and make this work in a positive way. I mentioned that the expense of these projects makes it inaccessible to a lot of actors and communities and NGOs who would want to implement these in good faith. So it almost makes it like only the very, very wealthy businessmen in Switzerland can access this market, which is really a shame because we have a lot of good conservation actors here. We have concerns about the independence and accountability of the decision makers, as everything is so centralized with the government. The decision makers are not truly independent. We have concerns about whether the partnerships with local communities will actually be fair. You know, the communities are not actually parties in the agreement itself. There has to be local investment, but the communities are not equal partners. And again, the extent of carbon rights, who holds these, and land rights, who holds these raise very real concerns of sovereignty, given that vast areas of land, water, and resources will be controlled by foreign actors. I mentioned that we already have somewhat weak land right protections in Zimbabwe for protected areas and communal lands. So these uses of the land as they currently are may be easily changed in favor of projects that maybe don't benefit the local community. The grievance mechanisms are weak, as I mentioned, limited due process, lacking independence. And then while they've focused on verification, transparency, and accountability of the actual trading process and emissions reductions, there's still quite serious gaps in terms of whether the actual terms of the agreement, sales, costs, profit shares, and benefit sharing, whether those details will actually be made public, and whether the communities will be given this information. There really need to be public audits on the benefit sharing and profits, which are communicated to the community regularly in an appropriate manner. So just briefly, and apologies that my last slide is very busy. It's just in case anybody wants to look at the specific provisions. There are a lot of opportunities for legal challenges. I would say in Zimbabwe, environmental litigation is quite costly because there are a lot of different forums that you end up going to. So you need to, for example, appeal any decision by the Environmental Management Agency first. Under the Environmental Management Act, you need to appeal to the Minister of Environment. Once you get that decision, you go to the administrative court, but simultaneously, you may need an interdict from the High Court to stop anything that's happening on the ground. We don't have an environmental tribunal in Zimbabwe. And sometimes when you have all these low-level redress mechanisms, it can take more time because you have to show that you've exhausted remedies once you get to the courts. But maybe the High Court is the only court that can really make an order, an urgent or interim order that will impact what's happening on the ground. That said, there are these forums that I've mentioned, project level redress mechanisms, national redress mechanisms. The regulations provide for appeals against decisions of the Carbon Market Authority. The appeals provide that you appeal to the minister during which time, pending that decision, the project is suspended. Unfortunately, if you disagree with the minister and appeal to the administrative court, the project is not suspended pending the outcome of the administrative court proceedings. So that can be a challenge. I'd be interested to hear how it's worked in other countries in terms of environmental impact assessments, whether such a project will fall under the EIA procedure. I'm not quite sure. But if it does, then there are various stages where members of the public and interested parties can engage with that process and appeal any decisions for the grant of an environmental impact assessment certificate. Then we have various laws like the Administrative Justice Act that protects administrative justice. So you can make an application to the High Court to review any decisions or activities by administrative authorities that you consider to be unreasonable, unfair, or unjust. And you can request information through that act and also through the Freedom of Information Act. If you don't get the information from the authority that you're requesting information, you can then appeal to the Zimbabwe Media Commission. And I have had quite a positive experience so far with requests for information under this act, which is also relatively new. Yeah, so it is helpful. And then we have, as I mentioned, quite a strong constitution, which protects the right to a healthy environment, water, food, access to information, administrative justice, property rights, equality and non-discrimination. And there's a provision under Section 85 that allows you to take a case to the High Court or the Constitutional Court for enforcement of those fundamental rights. Again, you may have a challenge of which forum will be acceptable, given that there are all these different pieces of legislation interacting. And something that we haven't used much in Zimbabwe, which I hope we can use more in environmental litigation, and I think we'll really need with this, the climate change management and the carbon trading framework, is using international experts and organizations to submit amicus briefs. So amicus briefs are when you're a friend of the court, if we have any non-lawyers listening. That's you're an international, you're an independent expert providing advice to the court on how to implement particular laws, and that is provided for under our new High Court rules. So I hope that we can maybe work together to submit some of those. I think I'll stop there. I've gone into more detail than I intended to, but I hope that it's been interesting to see what a domestic compliance mechanism can look like and to give us some ideas on where we can go from here. Thank you.
Thank you so much, Fiona. That was an incredible presentation. And I think what Fiona is basically asking us as lawyers to do is to take up the mantle and responsibility of seeing what the legal opportunities and possibilities are. As you've heard from her presentation, there's a lack of jurisprudential information on these carbon markets and credits in a lot of different countries. We really struggle to find any case law active in a number of jurisdictions that have a very thriving environmental justice industry and sector. So in South Africa, in Kenya, in Zimbabwe, I wouldn't say it's thriving there, but it's very challenging to find actual cases on these issues. So we really encourage you to look in your own jurisdictions and see what you can do there to litigate on some of these issues. I'm realizing we're running a little bit out of time with our interpreters, and so I'm going to sort of push forward some rapid fire questions to yourself and Yasmine. And I'll start with Yasmine to give Fiona a little bit of a breather and so that she can catch her breath whilst the interpreters are here. There are a couple of questions that have been tabled to us. One is from Grazia Skoza. I'm so sorry if I'm not pronouncing that correctly. It says, hello, and thank you so much for the brilliant presentations. What kind of accountability exists for companies buying these certificates, especially in cases where there are environmental or human rights violations involved? Similarly, when public funds from institutional donors such as the EU are directed to these initiatives, are there any accountability or reporting mechanisms in place for public transparency? I think both of you highlighted some of the gaps when it comes to transparency and reporting mechanisms, whether you can publish instances where credit's sold or bought, but I think that's the question, roughly. So Yasmine, do you want to attempt to answer that one?
Yes, I will attempt. Thank you for the question. And Fiona, thank you for that presentation. Oh, wow. It's very interesting to hear just how far Zimbabwe's gone. So yeah, that was very interesting. Thank you for that. So regarding accountability mechanisms, the legal frameworks themselves have certain mechanisms. So they may differ here and there, but based on the research that we've done with the frameworks that we've done, they are, so for instance, the document itself or the law itself would have like appeals mechanisms or dispute resolution mechanisms. They've got reporting mechanisms. They've got grievance mechanisms. So for instance, you can set out your grievance anonymously. So the document themselves would have these, pointed out. Section this says that if you want to, have a grievance, then you should follow these steps, and then you should, then send it through to the minister and all of that. So they do exist to a certain extent. The only challenge I would like to say is on a more local level, where these documents are set out in such a way that they're not very accessible to local communities. So you have this document that is very extensive, aka the Zimbabwean legislation, very extensive, but then these local communities are not aware of what is happening in those documents. And so even the fact that they're not consulted about the projects beforehand. So they're not really told about what their rights are. So the documents could have these processes, but enforceability is going to become an issue for specifically local communities because they're not aware of what the document says. And I think this is where us as lawyers, as practitioners, and as consultants, that's where we come in to make it a little bit more accessible for local communities so that they understand what their rights are, so that they understand what the accountability mechanisms are in the documents, so that it's just a little bit more transparent to them and accessible to them. I hope I was able to answer that question to the best of my abilities.
That was perfect, yes. And Fiona, I'm going to table a different question to you. It's going to be related to some of the more international and regional integration efforts that we can use to resolve some of the problems and challenges that we highlighted throughout the conversation. So should we be looking less domestically and a little bit more regionally for assistance in how, whether it's from an interpretation standpoint? This question is from Anne Njoro. Okay, from an interpretation standpoint or just from a jurisprudential standpoint at when solving some of these challenges?
I think it's a great question. I'm hoping that maybe some of the environmental law experts can also assist me with this. But I think some of the efforts that have been made for advisory opinions at the ICJ and the African Court on Human and People's Rights should hopefully help with some guidance. I know that there was an effort in the recent request for an advisory opinion from the African Court to include some provisions on carbon trading and climate change management. So I think it is really important to get this kind of guidance also from the UNFCCC and the incoming 6.4 mechanism, or is it already there? I'm not sure. I think it has sort of started, but not clear. It's not very clear. So I'm hoping that sort of guidance will be clearer as we go along. I think the UN really need to help with monitoring, especially the independent crediting standards. They need to be monitored more closely, as we saw with the Kariba Red project in Zimbabwe. So I think there is a lot of effort to improve on those standards and verification. But I do think that there's a bit more focus on the verification of emissions reductions which is a good thing, but maybe a bit less on communities and benefit sharing. So maybe that's where we as the human rights community also need to be making use of the human rights mechanisms. So at the African Commission on Human and People's Rights, for example, and at the UN UPR mechanisms, for example, Human Rights Council resolutions, that sort of thing. But Yasmine, please feel free to add more from the environmental mechanisms that might be there.
So thanks for that. Not so much on the environmental mechanisms, but more on a Africa's falling behind conversation. I think, moving up to a more regional conversation about carbon markets is timely. I think it's our time for us to really come together as a region and deal with this heads on. And as much as we do have all these, laws popping up from the different jurisdictions, I still think that, like you said, getting the African Union, the Commission for Human Rights involved is timely, before we fall behind, like we always do. So, that was just a little thought.
Thank you both. Before I table my next question, I sort of want to rope in our attendees into the conversation again a little bit. I'm going to basically highlight the second poll question. And the question is, in your view, what is the most pressing challenge in Africa's carbon markets? So the options here are a lack of transparency, weak community participation or consent. Is it inadequate legal frameworks or enforcement? Is it exploitation and benefit sharing imbalances, or limited public awareness or access to information? So please feel free to pick any one of those options. And then I'm going to table the next question to you both, Yasmine as well as Fiona. The next question is, it comes from, again, Grazia, who says, what's difficult for me to understand is that based on this presentation, the carbon credit project aims to generate profit, and only 20% is returned to the communities. This makes it quite hard for me to reconcile this activity with the nature of NGOs involved in tree planting and selling carbon credits, which was provided as an example in the first presentation. Are these essentially businesses in practice then? And thank you for the clarification. Whilst you're thinking about the answers to that question, there was also a response from the chat during the first presentation, when you were highlighting, Yasmine, what carbon markets and credits are. And June Okelo says, it sounds more like pollution permits rather than carbon permits. So that's the response that we have there about the type of infrastructure, at least in framework, within which we are working with when we're discussing these markets. And even as civil society or NGOs that are doing great work and wanting to still preserve the environment, we can sometimes be complicit in the exploitative nature of these markets. Not sure if I should start with you, Fiona, in response to that question now, and then Yasmine, go ahead.
Well, I think the question sort of answered itself in a way. Certainly, the 20% to local communities is very limited, and there's no actual funds going to the communities. It's just the investment in local infrastructure, which could be a very positive thing if it's done well. But you could find that, people are just digging boreholes when there's no need, or, not really addressing the genuine needs of the community. So as I mentioned in my presentation, it's not a genuine partnership, and it is very limited in terms of access to sort of very wealthy corporate actors, as opposed to the local NGOs. So I hope that somehow perhaps foundations or other environmental funders will take note and look at a market like Zimbabwe maybe as an opportunity to see how can they support genuine conservation actors and communities to actually use these mechanisms themselves without relying on these corporations that are causing the problems in the first place. I do think it is just like the problems with critical minerals. It does feel like an extractive model all over. So thank you for the question. I think it was a really good one.
Thank you, Fiona. I think she's covered most of it. And thanks for the question. I think just want to answer the last part of the questions where it was said, are these essentially businesses in practice? So are these NGOs businesses in practice? And my answer to that is they're just unregulated NGOs. They're just unregulated NGOs because some of the examples that I can read of some of the carbon market issues regarding land rights, they were all NGOs. So for instance, we have the Face Foundation, which is a Dutch NGO that was based in Uganda. And that NGO was said to, I think it was displaced quite a number of indigenous people of the Ngobo, so the Ngobo people. And then another one is, for instance, in Tanzania, it's called the Green Resource Norwegian Foundation. That was also said to, lots of communities lost land rights. I think wages for some of the community workers that were there were very low. So those that were assisting the NGOs, the community, workers, basically, their wages and their salaries were very low. They lost access to their farming rights. Another one was the Mayandobe in the DRC. If I'm not mistaken, that was also an NGO from somewhere. And that NGO also was said to have, a lot of indigenous peoples had lost their rights to their ancestral lands. So for me, that last part is not necessarily businesses in practice, it's more just unregulated NGOs. Yeah.
Thank you. Great contributions from you both. I think this conversation really makes me think about the fact that there's more capacity development that needs to happen in this area. We've relied on Fiona a couple of times in a lot of ACA's capacity building training workshops, and maybe there needs to be a more targeted one, roping in Yasmine from SEJA and other stakeholders to just focus entirely on the regulation of carbon markets and credits. There was an input from Alfred Brown now, I think, in response to Fiona's question already about some of the international and regional mechanisms. He suggests looking at the African Commission, African courts, as well as the ECOWAS court and the East African Court of Justice. And then there's also a comment from Mikali, who, in response to Yasmine, who says, I strongly support Yasmine in that there have not been attempts by lawyers to inform communities of agreements and their implications. There's a lack of public participation and access to information. The people don't know about carbon markets. If they had any knowledge, they would reject the whole idea completely. Nadia from Morocco says, in Morocco, we start to talk about carbon markets, but we still don't have a mandatory mechanism. We're afraid as communities to become a polluters market, but at the same time, as renewable energies hub, we struggle having discussions with decision makers as they see a climate finance opportunity. How important is it to be diplomatic in the way that we approach this problem? So a multifaceted approach, how important is that to keep our diplomatic channels open and not sideline government and private industry and come up with ways of finding a middle ground? That's to both of you.
Diplomatic in one sense.
Okay, so there's the input from Morocco, from Nadia, is that we were scared to participate and contribute effectively. You've got government interests on one side, you've got corporate interests on another side. And in a lot of different jurisdictions, as we know, Zimbabwe was highlighted, sometimes the political dynamics are such that you don't want to seem confrontational. You have internal grievance mechanisms sometimes that are set up in some jurisdictions. In other jurisdictions, you may have to go to a tribunal. In other jurisdictions, you may have to go to a court. In other jurisdictions, you might have to play the longer diplomatic game of just having a conversation, mediating conversations between these different stakeholders and their interests when you're defending a specific community. So how important are those diplomatic conversations, keeping that door open to diplomacy?
Very important to a large extent. I mean, we don't live in isolation. States don't live in isolation. And I would like to say that keeping those diplomatic doors open really emphasizes the notion of cooperation. We can't fully, one African state cannot fully address, the entire issue of climate change or, certain issues around environmental degradation without, the aid of or the cooperation of other countries. So I think being diplomatic is important because of the element of cooperation. We all, the international community needs to get involved, but the only way you can get involved with the international community is if you keep things as diplomatic as possible. So yeah, it's important for cooperation. Yeah. And yeah, I was actually going to speak about how diplomatic, for those of you who watched Cyril Ramaphosa and Donald Trump's address yesterday, and how very diplomatic President Cyril Ramaphosa was. And it was very strategic and it was necessary because this is the international community. So yeah, that's a very good example of diplomacy. So yeah, I think it's very important for cooperation. Yeah.
Fiona?
Yeah, I agree. We need to be really careful not to throw the baby out with the bathwater, that we do need nature-based solutions and some sort of climate financing. We need to access funds. This system is not one that we necessarily approve of, but it's what's there now. So let's engage with it, respond to it, make our voices heard in the platforms where these decisions are being made. But we have to be aware of the power imbalances, that the big polluter countries are the ones who who have caused this problem, and now as Africa we're suffering the consequences. So there needs to be some sort of mechanism where our governments do receive some sort of funding or are incentivized to protect the environment. But we don't want to replicate power imbalances that were, happening in colonial times in terms of the government and communities. So, as lawyers, I think we are going to play an important role in terms of representing community interests and representing the interests of the continent in international forums, and making sure that we improve these systems, because we are in a crisis situation in terms of climate change, and we need to make sure that human rights are respected in the solutions.
Thank you so much to you both. Thank you to our panelists, and also to, I think, our audience members who were incredibly interactive and participated, even though this is a very novel channel of waters for all everyone has been using metaphors around waters, and so I decided to copy Fiona. So even though we are navigating new waters, I think we were able to discuss this quite effectively. There's a question here by Brighton Ayampa that I'm going to answer. He says, great discussions. I need public awareness for carbon markets and grassroots conversations. I've got a separate question here about whether or not we have strong national legislation on carbon markets rather than international instruments that are ratified by specific countries. And where you will get that information, Brighton, is in our guidebook. You're going to find the guidebook on ALCA's website, and it's going to detail for you a number of different jurisdictions: Kenya, South Africa, Zambia, Zimbabwe, the DRC, Rwanda, and highlight to you what the internal mechanisms are that help to regulate some of these carbon markets. Are there specific agencies in which you approach when you're wanting to register a project. What are the grievance mechanisms and how do they differ between one jurisdiction and another? What are some of the issues that we think as a lawyer you need to look out for if you were ever to challenge some of these projects? Think issues around justice, around gender, equity and dynamics, issues around land tenure and sovereignty. All those things are going to be highlighted in that guidebook. So we really, really encourage you to engage with our social media and look out for that resource. I'm also going to email the resource to everyone who was on this specific call. So this was our first webinar series for the year, and we really hope that it sparked reflection and clarity on some of the complexities of carbon markets and the need for a rights-based approach in Africa. So I'm really going to encourage everyone to carry this momentum forward, whether it's through advocacy, through your research and your different partnerships with the networks that you work with. And until next time, please take care and stay engaged. And thank you again to our interpreters, Structivate, as well as our panelists. Thanks, everyone.